5, 4, 3, 2, 1, start. This revision has been filed questioning the correctness of the order of the learned additional district judge in a small causes suit whereby the opposite party has sought ejectment of the applicant on the ground of arrears of rent. Stop. The allegation made by the opposite party landlady was that the applicant is a defaulter and therefore the premises in question should be vacated and peaceful possession be handed over to the landlady. Stop para. Shri Atul Dayal, learned counsel for the applicant has raised two issues. Stop. Firstly, that the house in question was an old house and therefore the finding that the UP Act number 13 of 1972 was not applicable, is incorrect. Stop. Secondly, even otherwise whether the house could be construed to be a new building was dependent upon a specific finding with regard to the date of first assessment of the new construction, which finding is absent and therefore the impugned order is liable to be set aside. Stop. He further contends that the burden had already been discharged by the applicant tenant by denying the allegations of the new constructions and the landlady has failed to establish the date of first assessment, therefore, the impugned order is liable to be set aside. Stop. Para. Shri Atul Dayal further submits that the reliance placed by the court below on the sanction of the map in the year 1989 and the factum of mutation on 1/12/1990 was totally irrelevant for the purpose of construing the date of construction of the new building. Stop. He submits that the court below has committed an error by proceeding to record findings on the strength of evidence which was foreign to the provisions of the Provincial Small Cause Courts Act, 1887. Stop. Para. Shri Arvind Srivastava, learned counsel for the opposite party, on the other hand, contends that the arguments of the other side is putting the cart before the horse, inasmuch as the applicant has failed to dislodge the finding regarding new constructions and that the landlady has discharged her burden by clearly stating that the building had been newly constructed, for which a map was sanctioned in the year 1989. Stop. Accordingly, it was submitted on behalf of the opposite party that the applicant having failed to lead any evidence to the contrary, the finding recorded by the court below cannot be said to be perverse. Stop. Para. From a perusal of the impugned order, it is evident that the building has been constructed newly, for which a mutation was also carried out on 1/12/1990 in favor of the opposite party. Stop. The landlady had taken a clear plea that the map had been sanctioned. Stop. Except for a bald denial in the written statement of the applicant, the onus was not discharged by collecting and filing of any other document to the contrary. Stop. The applicant could have approached the map sanctioning authority to find out as to whether the contention raised by the landlady is correct or not. Stop. Not only this, comma, the argument advanced that the date of first assessment would be relevant, comma, could have been proved by filing of the extract of the assessment of the municipality. If any suggestions regarding speed, legal or general matter and advanced outlines will be welcomed in the comment box. Thank you.